Okay, so we're gonna just like
Yes, we're gonna wing it.
And we're live. Okay.
black people.
So, Virus gotta go to bed. Oh well. So, this stream, we're gonna just very quickly run down some unfortunate circumstances surrounding a particularly good lawyer, in my opinion, except for just recently. Marc Randazza. He's actually been, if you can go search his name on the internet. He was involved with the John Steele lawsuit series of hilarious events. But apparently he has decided to go counter to his normal intelligence and knowledge of the copyright law, and especially in particular DMCA, and he filed a DMCA to remove an article about himself on WordPress, citing that it's an unflattering story and that's not fair use. So we'll go ahead and go down this quickly here, and I have a couple links up that can help things along later on involving fair use and the copyright law.
Oh boy, this is gonna be fun.
Yeah, this is just amazing. So, embattled copyright lawyer uses DMCA to remove article about himself. Marc Randazza tells WordPress that the unflattering story is not fair use.
Okay.
You dumbass, Marc.
Now,
Marc.
before we get into this,
Marc.
for the two people that even care, Marc Randazza typically is the type of dude who would be against using DMCA for purposes such as this, which is why it's so shocking that he would utilize the law in this way.
Absolutely. He was instrumental in a case, I think actually maybe you mentioned it in this article, he was instrumental in a case whereby the wholesale copying of a work can be construed to still satisfy at least one of the four factors for the fair use test. So we'll actually be covering that in brief later on as well.
Yes,
just to get on in here though. See,
for now, let's go on to the article.
Yep. Let me just click on me. There we go. So, well-known copyright lawyer Marc Randazza used the DMCA to delete an online article about a dispute between his former employer and himself. You jackass. See, Randazza says he sent the notice on behalf of xbiz.com, a porn industry news site that he represents. That's still uncharacteristic. See, last July, XBiz published an article about Randazza's legal dispute with a former employer, gay porn publisher Liberty Media. Oh, man. The brouhaha with Liberty Media was also featured here in our story titled Bribery, Gay Porn, and Copyright Trolls, The Rise and Fall of Lawyer Marc Randazza. Let's see, it describes how an arbitrator found that Randazza, the Nevada lawyer, was championed for helping bring down copyright troll Righthaven. That would be John Steele. Righthaven was a massive copyright troll, and they finally got bench slapped off the docket.
Yep.
So he said he solicited a bribe.
Wasn't he doing that for a couple years?
Yeah. The Righthaven was the Righthaven debacle across the western United States took about 2.5-3 years to get over with.
Yeah. Yep. I remember.
It was circa 2010 to 2012, something around there.
Yeah, something like that.
It wrapped up by the end of 2012. Remember that?
Yeah, I know it didn't go past 2013.
Yeah. So let's see. This article describes how yada yada. So Randazza soon found himself under investigation by the State Bar of Nevada. Yeah. Because he solicited a bribe in a bid to settle a copyright case for Liberty. That was not smart. Let's see. A blog called Fight Copyright Trolls. Decent blog. Mentioned the arbitration award as well. The blog's owner, who goes by SJD, also noticed that the XBiz article had been changed, but he had kept an original copy saved and published as a PDF file on his site. And this is why when you publish things on the internet, just think that they're always going to be there. On February 1st, nearly 7 months after the FCT blog published the XBiz article and a related commentary, SJD was on the receiving end of Randazza's copyright takedown request. God damn it. See, the FCT blog had republished the entire XBiz story, and Randazza claimed that made it a piratical infringing copy. Except you're the jack... Oh, here it is. I'll just go ahead and say it. It was Randazza himself who was instrumental in proving that even reposting an entire article can be fair use.
Yep.
In one of the cases where he bested Right Haven. Like, this is one of the landmark cases he was a part of, that he was...
And in fact, he's gone on public record multiple times stating how such things as this are one of the major reasons why our copyright system is fucked. So
this is a major problem he sees with copyright. Let's see. Nevertheless, Randazza sent the DMCA notice about the FCT blog to Automatic, who owns the WordPress blogging platform. Randazza was demanding that an unflattering article about himself be wiped from the internet, in the name of his client XBiz, which continues to host an almost identical version. The DMCA legal notice didn't lead to quick compliance, however. Instead, Randazza got into a back and forth about copyright law with WordPress community guardians.
Marc.
So what's the verdict? It looks like Rhett Pardon is the author of the article infringed upon, and you're actually the subject of the article. A WordPress community guardian identified in emails as Sal P. told Randazza. Do you work for XBiz, and are you authorized to represent them in this way? Well, that's a fantastic question. See, Sal reminded Randazza that all information you furnish in connection with DMCA notices, including your authorization to act on behalf of the copyright holder, is submitted under penalty of perjury. And we'll get to that section in a bit. That's section 512F. I finally remember the number of the copyright. Of sections of USC 17. So we'll read that briefly. Let's see. I may be the subject of the article, but I am also legal counsel to XBiz, so that's a conflict of interest. Randazza wrote in response. Rhett Pardon is a pen name for the author, but Adnet Media, DBA, XBiz is the copyright owner. I submit this information under penalty of perjury. If you would feel more comfortable with a declaration from the actual writer, I will get that for you. Yeah. See, that's, at least he still has the balls he's known for.
Yep.
It wasn't over yet. The next day, a WordPress employee identified as Leroy. I don't want to know his last name. Really.
Leroy Jenkins.
Responded with, "At least I've got chicken." Responded asking Randazza if he had considered fair use before sending a takedown request. By the way, something that's required of you. Leroy had noticed that there was a key difference between the current article up on XBiz and the original XBiz article preserved by SJD. As you may know, the DMCA is frequently abused by complainants who are not authorized to act on behalf of copyright holder, but nevertheless seek to remove certain materials from the internet on copyright grounds. Leroy wrote, "We are very vigilant about this issue," which is horseshit, but, at least in this case, they kind of picked up on something. Okay. So he continued. While the blog plus you cite, arbitrator Marc Randazza must pay $600K for clear and serious breaches of fiduciary duty against his former client. Does include an article from your client's website. It appears that the article is included for the purpose of commentary by the blogger, which is protected, by the way. That's under the 4-factor test.
Yep.
So that's the transformative use right there. If you are doing it for commentary purposes, that's transformative.
Yes.
Period.
If you take a copyrighted work and you put commentary to it, it becomes a transformative work and pretty much denies.
Do the right thing and reference back to the original. But at the same time, you don't have to worry about copyright. That is clear fair use.
Although there are people, idiots, who will still try to claim, even with the transformative work, that they still own it. Which
of course they will. This is why. So I wrote an article a while ago about pre-screening all of YouTube and the scalability issue that comes out of that. And that was one of the that's the raison d'etre for the whole entire article. That's the whole purpose behind it. Motivating it is you have to have an adversarial trial to declare whether or not something is in fact violating copyright law or is in fact fair use. So let's see. In particular, the article includes and makes reference to an earlier copy of your client's article, later revised on your client's website, and notes comments on the deletion of the 2 paragraphs from the article. First glance, it seems like a colorable instance of fair use by the blogger. A copy of the earlier version of the article is essential to the blogger's commentary. Well, yeah.
Yep. And just to bring this up real quick, me and you have talked about this many times, Craig, but not many people know about this, but for all of you who either care or don't, the Digital Millennium Copyright Act is not the main copyright law in the U.S. It is actually the Copyright Act of 1976, which has multiple sections and subsections which directly conflict with the fair use doctrine under the Copyright Act of 1976, which is why we have idiots now who will claim that no, my DMC is perfectly valid to take your fair use out of the picture.
Yeah, so fair use was a doctrine that stretches all the way back into the 1800s. It was codified. It was part of jurisprudence. Like, so it was basically it was by case law defined, but it was codified in 1976.
Exactly.
So under Section 107.
Yep.
So that's one of the other tabs I have open as we're going to go through those.
Yes.
And then, of course, what you can do should someone falsely claim against you in a way that you can prove. There is remedies that you can seek.
The burden of proof.
I mean, you do have to be able to prove it, but sometimes it's pretty easy.
Yeah.
Let's see. If fair use is applicable here, the blogger's use of your article in this context would not constitute infringement, regardless of authorization, because fuck you, that's why, by the copyright holder. Seriously, go fuck yourself. So did you consider this fair use defense when submitting your notice? That's required, by the way. Do you agree or disagree with this assessment? Which would be, that is a statement I would not answer if I were him. See, which would be interested to know your thoughts before proceeding further, particularly given your firm's experience defending small publishers against similar takedown requests, which we very much applaud. Like, this Randazza is known for this shit. Like, he's known for helping against these kinds of fraudulent takedowns.
Yes. That's why, like, when I actually read this, I thought this was the joke article originally. Like, I was like, Ben Randazza? No way. He's been fighting this stupidity. Why would he entertain it and be a part of it?
So my client's position, Randazza responded minutes later, is that this infringes upon their copyright and that it is not fair use.
Yep.
Which means he probably didn't directly answer out of these questions, which is a smart thing to do in this case because those would have easily sealed a summary judgment against him. See, about 2 hours later, Randazza wrote another note to Leroy. So what's the verdict? Do you want to have a phone call about it? You can feel free to record it if you announce that in advance. I just think that dealing with someone with just a first name with multi-hour delays in between messages is not constructive. Well, Mark.
That's what I meant, by the way. When I said Ben Randazza, I meant Mark earlier. Sorry, my mind's wandering.
Just like, this could have been solved by you not filing a DMCA request like this. See, later that night. Yeah, go ahead.
Yeah, this is the other thing. Like, Mark, he's never going to hear this, but, like, buddy, why would you even put attention to this article when it's been out for so long?
Well, it's because he's on retainer for. Well, he was hired by XBiz to represent them, I guess.
Yeah,
I would have. See, he's normally a guy who I would think could be principled enough to tell them to go and shove it unless he signed a contract that compels him, for whatever reason, to do this kind of shenanigans.
I get that. It's just like...
he's normally the guy I would think would resign his commission to get out of doing something so stupid as this.
Yeah, I don't know, man. Like, an article like that, like, it would have drifted off into the bowels of irrelevance of the internet had he not done this. Now it's all over front page freaking news outlets.
This is Streisand effect,
exactly.
which I know he's aware of.
Yep.
Let's see, my client has authorized me to withdraw the DMCA request. Okay, well, then you should have withdrawn it. Like,
Yeah.
this would have, it's silly, but it still would have been less silly had you. Okay, missing paragraphs.
Yes.
In telephone interview with ours, Randazza said his request to remove the article about him was simply one of many DMCA notices he had sent on behalf of XBiz. That's not going to do any better for you, buddy.
Nope.
There are hundreds of infringements that we deal with, Randazza said. When this one was brought to my attention and there was some question as to my potential objectivity on it, I asked my client to allow me to withdraw it and refer it to another lawyer. I don't know who's going to handle it going forward. Okay, see, that is more reasonable. The XBiz article is written by Rhett Pardon, a pseudonym used by Don Parrott, XBiz's executive editorial director. Phone and email requests for comments sent to Parrott, XBiz publisher Alec Helmy, and XBiz's press relations department received no response, which is not surprising because XBiz is like that. Randazza declined to say who at XBiz authorized the DMCA takedown notice, probably because it was a department head or a departmental
Yeah, and he's under contract. And he's probably under contract,
Yeah,
which is not at liberty to discuss unless he wants to get sued.
which is fine. You know, it's the way it works.
Yeah.
CS for SJD, the pseudonymous author of the Copyright Trolls blog, he views the Randazza DMCA notice as an attempt to erase history. Well, that's exactly what it appears like. It may or may not have been Randazza who was responsible for the original request, but certainly his behavior thereafter is unfortunately staining his name. Let's see. I felt what was going on was censorship, SGD said in a telephone interview with ours. The notion that I drew page views from them was so ridiculous it doesn't pass the smell test. Pretty much. The XBiz article discusses the same Randazza employment dispute that ours reported on in November. Liberty Media, called by its brand name Corbin Fisher, in the XBiz piece, won an award against Randazza of more than $600K through binding arbitration. So the arbitrator found that Randazza had improperly worked for Liberty competitors and had successfully concluded negotiations for a bribe in the amount of $75,000. Court proceedings to finalize the award are on hold due to Randazza's declaration of bankruptcy last year.
Ooh.
I actually hadn't heard about that.
No, I hadn't heard about that either. He actually declared bankruptcy? That's fucked up.
To get out of a $600,000 award.
Look at what they say in parentheses. The arbitrator did not conclude, however, that Randazza actually received the $75,000. Okay.
But he concluded negotiations, never received the award. Let's see. As WordPress's Leroy saw, however, this critical difference between the article currently up at XBiz and the original preserved on the FCT blog. Even though DMCA was dropped, SGD has removed the full PDF and updated the post with a screenshot of 2 paragraphs that were deleted from the originally published story. The 2 paragraphs describe a proposal by Randazza's attorney to settle Randazza's employment dispute with Liberty Media by offering in part $20,000 per bar license that Randazza is able to keep from having suspended or revoked. Well, you know, skirting by the seat of your pants here. Liberty's COO, Brian Dunlap, has described the offer as an unethical bounty on his bar licenses. Ouch. Intended to encourage Liberty not to cooperate with state bar investigators. Well, you know, you either cooperate or you don't. And if you're going to go the graft route, prepare for another bribery issue. The deleted paragraphs read: part of the settlement offer was to pay us $20,000 per bar license he is able to keep from having suspended or disbarred. Liberty Media COO Brian Dunlap said, in other words, he offered us a bounty on his bar licenses. We'd get more of the award if we did not cooperate with bar investigators or send follow-up complaints. In his attorney's own words, they said they expect suspension, disbarment in Florida, so he could expect $80,000 if none of the other 4 bars took action. We refused this offer because it was insulting, it was unethical. An attorney cannot offer such a bounty on their license because we know most all bars use reciprocal discipline. If one suspends disbars, the others usually do as well, which is true. See, the original email, which is a PDF here, was provided to ours, shows the settlement offer included at least $200,000 in addition to $20,000 per non-suspended bar license. The offer was made in June, shortly after Liberty had received the favorable arbitration decision. Liberty rejected the offer. Randazza didn't respond to R's questions regarding the deleted paragraphs. Asked if he was the subject of any bar investigations, he said none that have been closed. Well. Oh. Mark.
I don't know, man. The only thing I'm asking is, like, what was going through his head when he decided to do
it's
this?
like a last-ditch attempt there. Like, hey, I have enough money to bribe you. If you don't cooperate with investigators, it's like you've already been disbarred in one position, and the other four, it's like there's reciprocal action, buddy.
Yeah, no, like I said,
clearly he wasn't thinking.
Yeah, like I really want to know, like, what was going through his head when he decided to, like, go through this? What was his mental plan here? Because he had to have known this was gonna go south one way or the other.
Yeah. All right. So here's fair use. This is just them saying, "Welcome to the fair use index."
Yeah.
Whatever.
Blah 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 blah.
Yeah. So this is the actual fair use segment where they explain the 4 factors.
Section 107 of the Copyright Act of 1976.
We'll go ahead and read that real quick. Notwithstanding whatever, and so on, yada yada, these 4 factors have to be considered.
Yes.
The purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes.
Yep.
Second component, the nature of the copyrighted work. Third component, the amount and substantiality of the proportion used in relation to the copyrighted work as a whole. That would be the de minimis exception.
Yep.
And number 4, the effect of the use upon the potential market for or value of the copyrighted work.
Yep.
So
and
the previous part has a little bit of explanation for each of these 4 parts.
Yes.
Which you can go through. I just said the stuff around this doesn't really matter.
Yes.
It's just the 4 factors. Go ahead.
Now, for those of you wondering, like I said earlier, why exactly does the Digital Millennium Copyright Act directly conflict with the Section 107 of the Fair Use Doctrine in the Copyright Act of 1976? And very simply, it gives complainants the ability to supersede the court system. They can use the takedown request. And for YouTube's the prime example in today's thing. You make a video of a transformative work, right? Maybe a gameplay, and you do a commentary over it. That's definitively a transformative work. You should be okay. But some companies are sticklers, and they'll say, no, we're going to take it down. And YouTube, because of the Digital Millennium Copyright Act, has to comply with it. And they have
in order
to
to maintain safe harbor, which we'll cover in a second here, in order to maintain safe harbor is defined under Section 506 of Title 17.
Yes.
So basically, U.S. copyright law. In order to maintain safe harbor, they have to process the notice and takedown.
Yeah.
So basically, the person who has their work taken down has a whole 14 days to respond to the notice. And the counter notice can be processed immediately. The work can go back up while the counter notice is being looked at, and then at that point, the complainant has the option of taking the respondent to court, which means that the third party, which is the platform, is still maintained as a safe harbor. So basically, blame the person wielding a hammer, not the hammer itself, for knocking someone else in the head, that kind of thing.
Yes.
Wouldn't it be silly for someone to sue the hammer manufacturer for the defective use that someone else saw fit to use it for?
Yes.
So,
no, I mean,
I don't see anybody suing Ford for a person running someone down the street.
No, like you said earlier, you actually went through and determined that it would not be profitable for Google or Alphabet Corp or whatever the fuck they're calling themselves these days to actually go, do what the law says to court, have a judge.
Every single minute of video going up on the internet. No, not by a long shot.
Yeah.
This was back in 2012 when it was about 72 hours per minute that was being uploaded.
Now it's like what 108 or
and
something
it's
like
something
that.
ridiculous.
Yeah.
Like
So
even then, the total amount of money it would have cost was about $1 billion less than their gross income, which was
yeah,
like 38 billion. So it would have cost them around
yeah,
37 billion dollars at market value for the judges and the amount of time required. And that was just our jurisdiction. If you start
yes,
including everyone else, it goes up by a factor of 1,000.
yeah.
It would
So
have cost $37 trillion.
Google would go bankrupt.
Which is why it was
Yeah,
so fucking funny to me.
yeah.
Because I
But
just I showed my math, but
yeah. So
yeah.
I mean, I don't know. The biggest question I have for Mark is why? Well, like, what does he get out of this? What positive does he get out of this?
I
Because
have no idea.
honestly, does he get publicity? Because I mean,
He had
I'm
it. He was known for
yeah,
being a good lawyer. This is distinctly being a bad lawyer.
yeah, like because
Like
in this,
I didn't know about him being disbarred in Florida.
yeah, because
Like
I
that's
mean, in this context, not all publicity is good publicity. In this context, you don't want bad publicity. It hurts your image, your reputation. That's bad, very bad. So I don't know.
like it's upheld that you only have to satisfy one of these four factors, which
Yes.
everything involved clearly did.
Now, to
Um,
to give
we,
a little background, most cases you'll usually find that a work will uh, hold at least two of the
oh
four.
yeah,
But yeah,
you only have to prove one.
you only have to prove one, but most will definitely hit at least two of the four
Yeah.
on the test.
So it depends on how lazy the judge is as to whether or not they're going to bother even writing about any more than one, let alone two.
Yep. Yes.
But a lot of times, if you have a judge who's good about this kind of thing, they'll go through the full work of
Yep.
each of the four of them, and lay out what portion or what portions did or did not satisfy each of the factors of the test.
Yep.
Okay, so we can. Well, people can look this shit up on their own if they want to. Just go
Yeah.
to the copyright.gov/fair-use/more-info.html.
Yes, and one more time. That's section of 107.
Yeah, this is section
If you want to
107.
read,
This is the explanation on section 107. This
yeah.
is the actual section 107, limitations on exclusive rights or fair
Yes.
use.
Yeah.
This is section 107 of the 1976 Copyright Act.
Yes, Copyright Act of 1976, which is based off the Fair Use Doctrine.
So it's therein enclosed in Title 17 of the United States Code. So
Yep.
USC 17 section 107. That's fair
Yes.
use.
Yep.
Now, in that same vein there, this is USC 17 section 506F. I think it's 506F.
Yes. Yep.
Here. 512F rather.
Oh, 512? Okay.
Yeah, so I'll go back to 506 in a second here. But here's this
Sorry.
is all this shit above. The important part is really just this paragraph here in the middle screen. So
Okay.
misrepresentations. So this is kind of like your way of remedying things here. Any person who knowingly materially misrepresents under this section, one, the material or activity is infringing, or two, the material or activity was removed or disabled by mistake or misidentification, shall be liable for damages, including costs and attorney's fees incurred by the alleged infringer. That would be the person who got, say, the notice and had their content taken down. By any copyright owner or copyright owner's authorized licensee, or by a service provider who is injured by such misrepresentation as the result of the service provider relying upon such misrepresentation in removing or disabling access to the material activity claimed to be infringing, or in replacing the removed material or ceasing to disable access to it. Basically, if you can prove that you had if there was a what the IRS will call a realized deficit or a realized damages, that means like cash in hand kind of damages.
Yep.
If you can prove a monetary damage associated with a removal or a fraudulent claim on your content, then there is provided in the title a bit of remedy here. The problem is these lawsuits are notoriously difficult to prosecute.
Yes, because
and
you have
people will
to
typically
you have
settle
to
out of them
prove.
before they can happen.
Yeah. You have to be able to prove a multitude of factors, and it's a pain in the ass. And most times, one side or the other is willing to settle. You know,
Yeah.
some halfway agreement will be met.
Let's see.
Because,
And then here, 506 criminal offenses.
yes.
Same deal here. I have to go find it. 506 C, 506C. Here we go.
Yeah,
so fraudulent
506C.
copyright notice. So this is what would lead you to a 512F, is if you had a 506C violation.
And if you guys were actually listening and were paying attention, in the fair use thing, they actually mentioned Section 106 because that's one of the only exceptions to that. So
yeah.
that this is where fair use kind of falls short a little bit, or there's.
Well, so this would be how you declare whether or not, like, this would be how you declare a 512F seeking remedy or whatever.
Yeah.
This is 506C, fraudulent copyright notice. So this is the part where they were asking whether or not he had considered fair use, and then whether they were asking whether or not he had the rights to represent them legally with the with his pursuit of a DMCA takedown. Yeah. So any person who with fraudulent intent places on any article a notice of copyright or words of the same purport as such person knows to be false, or who with fraudulent intent publicly distributes or imports for public distribution any article bearing such notice or words that such person knows to be false shall be fined not more than $2,500. There's also false representation, 506E, which is the part that Randazzo is treading the wire on. Any person who knowingly makes a false representation of a material fact in the application for copyright registration. This is registration, or was it? No, this is still provided for in Section 409 or any written statement filed in connection with the application shall be fined no more than whatever. Yep. Basically, and here's the 106A exception.
No.
So basically, like if you commit perjury by submitting a DMCA takedown, knowing that you are doing something wrong here, this is the, weak as they are, this is what gives the law some teeth for the people who are being falsely flagged for their content being some kind of copyright violation. This is what you can use to go after people. This is what Thunderfoot was threatening Venom Fang X with because he kept false DMCAing his videos.
Yes.
I guess these are the teeth in the law that you can go back at someone with. Aside from just perjury, there's a statutory limitation built into the law here. Yeah. But this is per offense, so this isn't like, well, you false flagged a bunch of my videos. I only get to see this on you once. It's for each count.
Yeah. Now,
which can add up big time if you're like a copyright troll.
Yeah. See, this actually leads me to, and I actually talked with you about this before. Back in 2001, there was a company that reverse engineered, and this was proven legal in the courts 3 times. This is legal to do, by the way, because of the way they did it. I'm gonna get to that. That a company called Bleem reverse engineered the PlayStation 1, and they found a way to create a boot disc for a Sega console where you put the boot disc in, and then you have to put a legitimate hard copy of a PS1 game into the Sega copy, and then it would play the PS1 game. Now, because of the fact that you still required the hard actual copy of a PS1 game, they won because they were not infringing on the DRM or the product that Sony was licensing. Sony, however, continuously sued the shit out of them 3 times and lost every single one But this goes to show you that on actually both sides of the law, you can continuously be sued for each count and each offense, regardless of anything. Like, Sony lost all 3 of those lawsuits, but Bleem went out of business because they had no more money. So, copyright trolls can abuse the shit out of you to the point of running your coffers dry.
So this is kind of the take-home message on that. Actually, so the guy who runs Fark.com, shit, now I have to remember his name.
Yep.
Drew Curtis. So Drew Curtis had an issue with the patent troll a while ago, but he was able to make a TED video about his ordeal because of the way it ended. So basically, the patent troll that sued him and others for something very fucking obvious that had with the internet attached to the end of it.
Yep.
And he basically he tried to go forward with the suit, and one by one the other companies that were involved, like Google, Amazon, eBay, etc., they dropped out of it. But he continued, and basically he pointed out that he wasn't going to be settling at any point, and eventually they decided to try and settle with him. And he told them, basically he told them to fuck off until the settlement was for $0 exchanged. And when he sent back the final copy, he struck the non-disclosure agreement component of it. They put a paragraph in these, which is why you don't hear a whole lot about them. They put an NDA rider into them. So he struck that, and it came back signed, so he's allowed to speak about it.
Yeah.
But like the take-home message is to not negotiate with terrorists like these. Just basically make it obvious that you're going to be as much of a pain in the ass for them to prosecute as possible, and they'll back down typically.
Yeah.
Because nobody wants to have to go through this shit. If your work really is fair use, then if they didn't consider fair use when they were filing their claim, well, then that's their problem. You have every right to counterclaim, saying that mine falls within fair use. Just be aware that when you do that, you have to be kind of. It's not likely in many cases, but just be aware that you're probably going to have to be ready to go to court and prove your case.
Yes, and the shitty thing is, and this is why I really do despise the Digital Millennium Copyright Act, is that it kind of gives the bigger companies more power in courts, because like with the Bleem case, Sony sued the shit out of Bleem and they lost every single case. He's upstanding on every front, but because they had more resources, better lawyers, and more assets, they won either way because money talks. So that's the thing you also have to keep in mind. You can go to court and you can win the case, but if you're really gonna go down that road, be prepared that they will continuously sue you if they feel adamant about it. Because they can claim, well, we lost on this front, but because this video was, say, 20 minutes and you had this other part in it, that's a separate count entirely, and we're going to sue you on that one, and that one, and that one, etc. Yeah.
Well, I mean, that kind of wraps up that thing.
Yeah.
We can open the floor up to whatever the fuck else. I don't care.
Nick, what do you think?
I don't know. It's like,
I was gonna say kebabs are gonna be involved somehow. I have a feeling.
I figured too.
I didn't know you were so knowledgeable about the Copyright Act.
Yeah.
Well, yeah, I made myself knowledgeable because it's as soon as the Digital Millennium Copyright Act passed, I was like, I was reading up on it, and I was like, this doesn't make sense because it conflicts with other laws. It's unconstitutional, so it shouldn't have passed by design, but it did.
Yeah. So I've been up until like 2012, because then I had other things to do in grad school. But and I was an undergrad, I was a relatively active commenter, comment contributor on TechDirt. which does a lot of technology and law and so on.
Yep.
So just being able to bring my own expertise to it, and then be able to discuss the nuance of the law in the comment sections.
Yeah.
Rendatza was like the whole Right Haven case thing was something that was big on there for the couple of years it lasted, and Marc Rendatza he was kind of instrumental in that. He was a rather intelligent person, so I thought.
I think he still is. I think he
fucked up big.
Yeah, I think he had a moment where his judgment severely lapsed, and he's like, "Derp," and then and I think he realized he severely fucked up too little, too late. But I don't know. I hope he continues to fight the good fight and stops being a dumbass.
Okay.
I don't know. Is there anything else?
I mean, there was that Lori Penny bullshit we were doing before, but I don't really feel like reading that now.
Nah, dude. That whole thing with that other dude kind of killed that.
The noob kind of took over the end of that stream, and you know what? That was fine.
That was the end of that. I don't know.
Not a whole lot of positive to say about that interaction.
Yeah.
Oh well.
Maybe someday the
Nice
hidden
kid.
Maybe someday the hidden audio recording will get leaked. Who knows?
Who knows? I mean, I hear that the WLAE crew is good about getting those.
Yes.
Okay, well, we'll go ahead and wrap this shit up then. I'm sure all one person watching is probably me. Doesn't really give a shit about this at this point. Stop the podcast.
Peace.